three very limited issues.
Okay. Let's get started. Are we going to need a record for this?
I don't think so, Your Honor.
Defendants don't, Your Honor.
Okay. And Ms. Ish, what about you? You're muted. She's still muted.
I'm sorry, Your Honor, I'm dialed in. Can you hear me?
Yes.
You can hear me now. I'm sorry, I had to dial in. This is a fight between the other defendants and not us, so we're going to be sitting this one out. We do not need a record, but we would like to speak with you at the end of the hearing about the upcoming trial in February to get a feel for what's actually going to be happening there.
Okay. All right, let's proceed.
And thank you, Your Honor. Mr. Artiego is actually going to argue this for us.
Okay.
Thank you.
Good morning, Your Honor. So I want to focus first on the breach of the LOI, which is a counterclaim that was asserted by the defendants, or specifically FSG in this case, 5-Star Global. The APA, of course, is where a lot of the arguments are occurring, which is the actual document memorializing the transaction of the sale and contribution from 5 Points Holdings to 5-Star Global. But preceding that was a letter of intent that was executed by Caledon Capital, which is one of the defendants in this case, and 5 Points Holdings, which of course is one of the plaintiffs. So they have, and by they I mean FSG, has alleged a breach of the LOI. We filed no evidence motion for summary judgment, and we believe that should be granted. There are two good reasons for the granting of that summary judgment. The first is the fact that the actual counterclaimant asserting a claim of breach of the LOI would be 5-Star Global, but they're not a party to the LOI. So I think step number one, there's a standing issue, which is you got the wrong party asserting that counterclaim, and they have not attempted to remedy that issue on their amended counterclaims or really articulated any reason for how 5-Star Global is supposed to be asserting any sort of breach of rights or obligations under the LOI. So I think that's number one. I think even if we put that to a side, though, and just say, okay, let's just assume for the sake of the argument that 5-Star Global does have standing to allege a breach of the LOI, the issue is really one of damages because the APA was executed. So the LOI, that contemplated the ultimate execution of the APA was successful. And so even if we assume that there was a breach of that agreement, there could not be any damages as a matter of law, simply because, as Your Honor probably knows, I mean, a breach of contract, typically the measure of damages is benefit of the bargain, which is, the expectancy damages. Here, the expectancy was the APA, which was successful. No one argues that. So as a matter of law, any alleged breach would be harmless. And I think that's particularly the case here, simply because the alleged breach being argued by 5-Star Global was a breach of what is being termed as the exclusivity provision in the LOI. So in the LOI, there's a provision that says, hey, during the pendency of this LOI, 5 Points Holdings, you can't just go out and market this deal or shop this deal to some other private equity group. We want to make sure that we're exclusively negotiating during the pendency of this LOI. They've alleged that there was a breach of that because 5 Points Holdings had a contract with an investment banker during the pendency of the LOI. Well, a breach of the exclusivity provision, the expectancy, of course, is that they may go off and take another deal during the exclusivity provision. The fact that the APA was successful, that it actually did transact, should preclude any possible recovery under this theory that there was a breach of the LOI, specifically the exclusivity provision, simply because there is no damages. So, Your Honor, I will stop there and allow for the response, but we would ask that Your Honor should grant summary judgment on the counterclaim for breach of the LOI for those reasons.
Response, Mr. Tillotson?
Yes. First, as to parties, the specific issue he's raised is not in their motion. And we did carefully try to, because their motion was so broad, we tried to respond only to what they raised. At page 16 of the motion, It's a no evidence motion, and it asserts only that Mr. Holm is not a party to the LOI in his personal capacity, and therefore we sued both Holm and the entity. And because Mr. Holm himself, who's the defendant in this counterclaim, wasn't a party to the agreement, we couldn't have a claim against him. They didn't raise an issue about the plaintiff itself lacked capacity or standing as to the other defendant. The agreement talks about Cadian Capital and subsidiaries, and we would have done that or tried to do an assignment or a change, but this is the only issue they raised with respect to Mr. Holm. Now, he doesn't really bring that up. I agree, Mr. Holm is not a party to it. And we are prepared to proceed with just this claim between the entities. And we would treat Mr. Holm as having liability, if at all, under our alter ego claim, which they don't contest on summary judgment, so that if the jury found this was a breach for this agreement and they found Mr. Holm was the alter ego of this entity, he would be liable or responsible in that capacity, but not as a direct party. So that addresses the party issue. And if the court's going to allow them to raise other issues regarding parties or standing, then we would ask for opportunity to amend and address that specific issue. But it was really the Holm issue. Second, with respect to damages, first, the brief facts, there is this LOI. It has a exclusivity period that not just the company, but no one connected to the company is going to try and go out and shop separately from us. And that would bind Mr. Holm as well, but a breach by Mr. Holm would be a breach by the company. And they not only breached it, they nakedly breached it. They went out and signed another agreement with someone else to help them shop for it. So there's no doubt there's evidence of the breach. Now, here's the damages. There's sufficient summary judgment on at least 3 levels. First, at paragraph 11 of our client that we submitted his declaration, which is the appendix at 585, he testifies that had he known that they had breached this provision, exclusivity, that they were looking for others to shop them around while promising us, then one of 2 things would have happened. Either he wouldn't have entered into the APA, and therefore he wouldn't have all these problems associated with the APA where they're suing him for breaches under the APA and their fraud claims, and or he wouldn't have entered into the transactions, which means we wouldn't have been obligated on the Southfield loan, which is now an obligation and a liability, and or third, there would have been a different type of transaction. And he specifically says, because this would have undercut our confidence in you as a potential partner. Now, the specific dollar amounts we don't need to allege to get past a no evidence summary judgment. We just need to put on the fact that we were damaged. But there certainly is evidence from our clients that we wouldn't even have done this mess. So to the extent they claim we somehow hurt them or damaged them or incurred all these costs or liabilities, that wouldn't exist. And the court's already dealt with the summary judgment issues and is familiar with the Southfield loan. We wouldn't have that either. In addition, the agreement we do enter into, thinking they're in compliance with the LOI, which is the asset purchase agreement, contains as an express provision by the parties we're suing that you're in compliance with all agreements. And so it also then folds into you would have been in breach of the APA at the moment it got signed. So those are the damages portion of it, Your Honor. And obviously it's a no evidence, so the standard court knows is pretty minimal. But we think there's more than sufficient evidence that had our clients known that they were out shopping this company, nakedly breaching the LOI, that then the world would have looked very different. And to the extent that they're suing us based upon their claiming we didn't fulfill the APA, then those damages would at the very least be offsetting. Jury's entitled to find that they wouldn't have been in this mess in the first place, even if they're now in the mess and owe you some money, there would be at least those offsetting damages. So we think summary judgment on this claim should be denied. There's more than sufficient evidence to get to the jury.
You know, let me just say this. I think this is a close call. This is maybe something we deal with at directed verdict stage, but at this point, I'm going to deny the summary judgment. Mr. Artiaga, what's your second point?
Okay. The second, well, this is going to be, we're going to switch to the affirmative defenses now. So the first affirmative defense I want to focus on is release. This was a part of a grouping of affirmative defenses, such as merger, release, waiver, et cetera. We're not challenging the waiver or merger affirmative defenses at this point. And the reason why I'm pointing this out is that in their response to the release issue, they simply said that all of the evidence supporting merger and waiver would support the release claim. If I understand the response correctly, even though there's an acknowledgement, or at least an implicit acknowledgement, that there is no release agreement anywhere. They're not going to be able to point to any sort of document signed by the plaintiffs saying we hereby release any of these claims. It seems to be an implied waiver argument. They're specifically pointing to the merger provision in the APA, as well as Mr. Holmes' employment agreement. Of course, the merger agreement just simply says there's no oral agreements, that this is the only agreement between the parties, et cetera. And they're saying that by agreeing to those provisions, there's essentially an implied waiver. They don't use that term, an implied waiver. That's my interpretation of what they're arguing, because
You're only moving on release, not waiver, right?
that is correct. That's why I'm pointing that out, which is, to the extent they're able to show a waiver, that's still a live affirmative defense based off the agreement that we've withdrawn that issue for Your Honor to decide. But in terms of release, there's just no release agreement between the parties. And for them to try to sort of shoehorn those waiver issues into a release affirmative defense is just not appropriate. And they don't have any evidence of release. So
They're really trying to argue, release doesn't really seem to fit here.
Well, I agree, and I'm not trying to create affirmative defenses that don't exist. I mean, I don't want a jury charge like you pointed out that's 300 pages long. I just want to make sure that at the time of the jury charge conference, we're not told, well, that sounds more like release. So obviously, the court knows the issue, which is there's all these pre-contract dealings. They then sign an agreement, two agreements, an employment agreement and a APA, both contain merger and integration clauses. Our argument, and we adduced testimony at the appendix at 522 through 525, is Mr. Holm knows when he's entered into these agreements, that's now his relationship. There's nothing else. So whether he waived any he had before,
I think that's more of a waiver and merger issue and not a release. So I'm going to grant summary judgment on this.
I would ask you, if the court would do this, would the court just say that you think it's waiver, but hold just to hear the evidence, so that I'm not later told, sorry, release is out of the case?
I mean, it's an interlocutory order anyway, so you can come back at the charge conference and say, Judge, you grant an interlocutory order, but we can reconsider it now.
I just want to be able to argue he gave up everything when he signed this agreement with an integration clause. He knew he was giving up everything, whether that's release or whether that's waiver. I just want to make sure I can argue.
I think it sounds more like merger to me, but anyway, at this point, I'm granting summary judgment on the issue of release. What's the third one?
Your Honor, the third one is ratification. It's almost identical argument. They made the same argument, which is the integration clause essentially means that there's been a ratification. But of course, we pointed out in the summary judgment that they hit none of the elements of ratification. There is no document that says Mr. Holm or 5 Points Holding ratifies X, Y, and Z, which is the basis of our claim. Again, they're making a waiver and merger argument, which we are not challenging at this point. And we're asked for summary judgment simply because there's no evidence of any ratification on our side.
So I just want to make sure, I mean, I agree on the main APA contract claim that there's not a ratification. However, there is a breach claim with respect to the net capital calculation, as the court knows. And they claim that we're in breach of that because we didn't give the proper notice, that we disputed it. And the court heard their summary judgment on that and denied it. But we put on evidence that their dealings with us through the joint retention of Riveron to do a calculation constituted notice of our dispute of the working capital calculation.
And that was the ratification.
Right. And that the engagement of, therefore, there was any breach of that particular provision of a technical part of the notice or otherwise, they ratified any such breach and ratified the contract by continuing to work with us and do those. So if that's still preserved, I agree, ratification, the classic ratification, as to do we have an agreement, et cetera, will be covered through the merger clause arguments.
Your Honor, I would just point out that what Mr. Tillotson just said is nowhere in the response. I would have mentioned that certainly in the presentation. So this is a brand new argument. It wasn't even mentioned in the argument regarding the traditional motion, which is about the net working capital issue. So I can only argue what's in the motion itself and what's in the response. So at this point, since there's no evidence supporting that argument that Mr. Tillotson just made, we would ask that summary judgment be granted. If Your Honor is convinced that maybe there is a fact question under the theory that Mr. Tillotson just articulated, then I think there needs to at least be granting of a summary judgment in part, because I assume the ratification was really aimed towards the claims under the APA, which I think there's been admission that clearly there is no ratification of those issues.
Well, If I may just briefly respond, Your Honor, I will state on the record, we're not pursuing ratification except as I've described it to you. And we had already argued that before. So to the extent there's some other.
Is that in your, I don't recall that being in your briefing in response to this ratification argument.
Well, I believe when we did it combined, and I do believe we incorporated that as part of our argument. And I do believe I argued that at the last hearing, that there was either waiver, ratification, or acceptance of this based upon their behavior. The court asked me for specific cites to that evidence, which I then gave you. And the courts denied that. So to the extent there's some other ratification argument, I would agree we don't have that, but I don't think we can go back now and say we're going to take ratification out of that prior motion and undo it. So the way we did it was for ratification, waiver, release, and others, we referenced our responses and the evidence in the matter itself, and in connection also with our first two affirmative defenses, which were the agreements and the provisions. But we made it quite clear in responding to their motion for summary judgment on the net working capital part, which you denied. What we were contending were the fact issues with respect to that. And I'm quite positive I went over the same evidence I just did now for you.
You argued earlier that Mr. Ortiago shouldn't be able to make the argument on standing because they didn't precisely kind of what's good for the goose is good for the gander. I'm going to go ahead and grant summary judgment on this. So on two of the three grounds, I'm granting summary judgment. On one of them, I'm denying. Mr. Ortiago, can you go ahead and present an order as to that? Share it with Mr. Tillotson. Make sure at the beginning of the order that it says that this hearing was heard on January 7th, 2022. Try to get us the order, fairly quickly so it doesn't get stale. And I think Ms. Ish, you wanted to talk about the trial settings.
Yeah, Your Honor, I think we probably all want to talk about it. So we're currently set for jury trial on February 22nd. Now, of course, if you remember, the FSG claims are going to be tried to the bench, but Southfield still has a jury trial. And we've seen some stuff coming out of the courts about how different courts are planning to handle jury settings. So we wanted to get a sense from you on whether we need to be doing exchanges in 3 weeks or whether we're going to be pushing this jury trial, how we're going to proceed.
I mean, that's that's an eternity away from now. What I'm doing at the moment, this last week, I canceled jury trials because of the huge surge we have in the COVID cases. This week, I kind of talked to the attorneys and said, hey, what do you want to do in terms of jury trials? And they all wanted to move them. So I kind of gave them the option next. I'm sorry, that was for next week. And so, what I would say now is it's going to depend on kind of what the COVID threat level is. If it's still at this really high rate, I mean, the number of cases we're having in Dallas County is unprecedented. There was over 6,000 cases and huge increase in hospitalization. So if we're still at this stage for COVID, I don't anticipate I would try this case. If we, go back to orange, we can try this case normally. And I mean, orange COVID threat level. One thing I think you guys should strongly consider is, and I know that no one is going to like this, but is consider it 6-person jury, at least the possibility of a 6-person jury. If the COVID threat level is still red, but the numbers have gotten under some type of control, then I would be willing to do a 6-person jury. I have tried some 6-person jury cases and COVID threat level red, but everybody's in masks. And so I don't know if that's, I wish I could give you more definitive. I wish I knew what was going to happen with the future of this pandemic. I keep thinking it's going to be over and then it comes back with some kind of vengeance. And so I don't know if does that answer your question, Ms. Ish, or?
To some extent. I'd also love Mr. Tillotson and Ms. Pettit to jump in on this. We've got the issue of the bench trial, and we've got 20 plus claims between the plaintiffs and the FSG defendants that need to be tried to you, right? And then we've got one claim that is going to be tried to a jury on the Southfield side. And I just, I'm wondering, our understanding was that the setting in February was going to be for the bench trial. But we just really don't know.
I'm trying bench trials every week at this point, and I can, and so, you know, you're asking me something that's hard to predict, but I understand why you're asking. It makes perfect sense.
Mm-hmm.
What I'm doing, I'm looking at this as not just this case, but as my docket as a whole. We're up to over 1,300 cases, which is the highest my caseload has ever been. And so when I can try cases, I'm going to try, when I can try jury trials, I'm going to try jury trials. When I can't try jury trials, I'm going to try to clear out my bench trials. And so it may turn out to be a situation like, let's say Omicron fades away and this next new variant they're talking about never materializes, and we're back in orange or yellow or green, that I would probably try the jury trial if it's the number one case. But I'd try a jury trial that week. If it turns out that we're still in red and I can't try jury cases, then I would probably try the bench trial. I don't know if that answers your question, but
Your Honor, the only thing I would add to that is that previously Mr. Tillotson had suggested, and I had agreed, so Mr. Tillotson and I are actually on the same page on this issue, which is trying the two cases together and just bifurcate the claim that needs to be heard to the jury. Because any way you slice it, I mean, for the jury trial, I'm going to be calling all of Mr. Tillotson's witnesses and all of Ms. Isha's witnesses and all of mine. And then as to Southfield, I'm going to be calling all of Mr. Tillotson's witnesses and all of Mrs. Isha's witnesses. And we really don't want to take up the court's time for all of that repeat material to be heard to Your Honor in one instance and the jury on the other. So to me, it really makes sense that we try to do it together. It is consolidated right now. So that's the other wrinkle that needs to go along with what happens to this setting.
so you're saying, so let me make sure I understand what you're saying is, so if this is going to be, this would be a jury trial, but I would decide all of the issues between your clients and Mr. Tillotson clients, and the jury would just be deciding the issues between your client and Ms. Isha's client.
That's something that the parties had discussed at Mr. Tillotson's suggestion. We are in agreement with that, just to save the court's time and the witnesses' time as well.
You know, Your Honor, nobody's actually briefed that up or asked for that relief yet, so we haven't really had a chance to, you know, take it to our clients. But we're likely, we need to talk to our clients, but we're likely not inclined to that, given that there are literally 24 claims between Mr. Tillotson's clients and Ms. Pettit's clients that range from fraud to breach of contract claims that have zero to do with the one breach of fiduciary duty claim against my client Southfield. It would be asking a jury an awful lot to sit through days and days of testimony about breaches of APAs, employment agreements, and other stuff that has nothing to do with any claims against Southfield. The only thing that's relevant to Southfield's claims is Southfield's conduct.
Well, we disagree, Your Honor.
And I think it would be something that would need to be briefed up. But again, these are things that, you know, we've got a setting coming up, so we need to, maybe the parties can confer offline, but we do need to try to iron these things out.
I mean, I understand completely, Ms. Ish, your concern. I wish I could give you, you know, if we weren't in the middle of a pandemic, I could give you at least a higher degree of certainty of what was going to happen. And I understand completely. You want to know, hey, are we going to go? We're not going to go. And I can never really, even with, you know, if it wasn't during a period of pandemic, because we do have large caseloads here, I can never give certainty. But with the pandemic, there's even more uncertainty. I do agree with you that probably if you're not going to agree to that, that we probably do need to do some kind of briefing on it to see. And it seems a little counterintuitive that all of the same witnesses would be applicable to both cases. I mean, I don't know that for sure, but and I will say this, that as Ms. Tillotson, Mr. Tillotson and Ms. Pettit know, I'm a kind of a think outside the box kind of judge. And so, if there's a way that, if we can do this by agreement, that let's say there's 15 witnesses and 5 of them are relevant hypothetically to the claims between Ms. Pettit and Ms. Ish, maybe we try this kind of in a truncated way that you know what I'm saying, like don't make them listen to all the witnesses that don't really apply, because I think that's going to be complicated for a jury, and maybe do some kind of staggered, like have a closing argument for the jury, and then afterwards we finish the rest of the trial for the non-jury. I mean, I haven't really thought through all of this, but I share Ms. Ish's concern that I don't want to have a trial that 90% of it I'm deciding and 10% the jury's deciding, and they're listening to a lot of stuff. They just, it's this kind of case is confusing enough already. To try to get them to try to parse through that, I think could be difficult. So I'd urge you to think. Mr. Tillotson, you seem like you've been wanting to say something.
I just was going to point out to the court, I think the argument is actually the opposite, which is that the court is only deciding a small part, the jury will be deciding a very large part, and she shouldn't have to sit in for that whole large part. I just don't see any practical way, if we can get a jury, to try only the jury case and somehow excerpt them out. It seems to me the more likely result might be on February 22nd, we can't get a jury, and then you would decide whether or not you want to go forward with the bench trial between Southfield and Ms. Pettit's clients, knowing that many of those witnesses might later be recalled for a jury trial. So I think the issue is that if there's any bias, it would be to you, because you're going to hear a lot of stuff that's not really related to Southfield's claim, and she's saying I shouldn't have to sit around for that. I do want to point out one other thing to the court. We're set on February 15th in front of Your Honor in the Thompson case, Ricky case. And so if there's a jury trial that's going to go on the 15th, we hope it will be that one. And I can't predict how long that case will go, but that's also—
It'll be over a week, I would think.
Well, I won't speak for Mr. Godwin, but I will speak for Mr. Godwin. It will probably last longer than a week. So, but I just want to alert the court and all the other parties. There is a that case I think was set quite some time ago. And just from what I know from Parkland, I'm not optimistic for February. That said, I agree with Your Honor that the way COVID is now, 5 weeks or 6 weeks between now and wherever that is an eternity. And things may look very different. I hope they do.
And
I hope so too.
Yeah, I mean, and I'm going to go with the science and what is being, so but I also will say this, that I want to try cases. And so if we can try this case reasonably safely with, while we're in an orange or yellow, we've got to try cases at some point. And so if it's orange or below, you can assume that I'm going to be doing jury trials. If it's red, it's just going to be kind of more of a balancing. I'd vastly prefer a 6-person jury if it's red. And I may not, given, I can't say for sure, but I have not tried any 12-person jury cases while we're in red. I have tried a few 6-person juries. And so that's something, Ms. Ish and Ms. Pettit, you should, if you want to go to trial, that will increase your chances if we're in red. So, and again, some of this is outside of my control. Judge Moore may decide that she wants to shut down jury trials again, which I fully respect. That's her decision. And so I may not have a choice. So, so that's the other kind of issue out there, or the Supreme Court may shut down jury trials. I mean, I don't know. So I wish we could give you a little more certainty, Ms. Ish.
No, thank you, Your Honor. It's extremely helpful. I just want to make sure, I think Mr. Tillotson spoke wrong. I think Your Honor, that the Southfield claims are the only one that would go to a jury.
I'm sorry, I apologize.
So his client would be the one in front of you. But I just wanted to make sure we were clear on that.
And I want to make it also clear that there is a possibility that if the pandemic is continuing to rage and it looks like that there's no end in sight, I may just try the non-jury case because I have time to do it. I mean, I'll just be honest. And
Are you doing those by Zoom, Your Honor? I mean, would you do
Zoom.
that by Zoom? Okay, fair enough.
I would definitely do them by Zoom because if this case goes, the non-jury portion of it goes alone, it's going to be because I can't try the jury case. So so there's a lot of moving parts here. I wish I could give you a little more certainty, but that I just want you to give you the rationale of where we are, and we want to give you as much information as we can.
This is extremely helpful. I think the parties can talk on the back end now and try to make some decisions.
And you guys, I don't have any hope this case is ever going to settle, but is there any chance that you guys could settle any of this case? Now that we have Mr. Tillotson on board, have you guys discussed mediation or?
Ms. Pettit and I, without revealing any 408 communications, have discussed the matter. I'm going to take another run at it as we now are closer to trial, and the court's, ruled on the summary judgment motions. And so I will use my best efforts with my client, Ms. Pettit, to see if they're.
Would it be helpful to go back to mediation? I don't mind ordering you guys back to mediation.
No, Your Honor. I think if mediation will be successful, I can get my clients to agree to it without a court order. And
Okay.
I'm worried if there's a court order for mediation, they won't focus on it till that actual mediation comes. And I'd like the opportunity to see if I can do something before then.
Sounds good. All right, guys.
See Mr. Lynn and Mr. Friedman. That is my cue to exit, Your Honor.
I know. I was going to say hi to Mr. Friedman and Mr. Lynn as well. I miss seeing you guys. So good to see you here.
Am I on anyone's witness list? I'm
I'm
going to log on to the YouTube and watch, but I'm signing off here.
All right. See you later, guys. This is going to be pretty short. All right. We're here on Fisher v. Fisher. I got the email from Mr. Roberts on this. And so, Mr. Lynn, did you have any objections to the form of that order?
Well, we would incorporate all of the objections that we previously submitted in writing. I think they apply as well to this order, the primary one of which is that what you're asking the auditor to do exceeds 172. The 172 is Your Honor is aware, because I think you and I have been through another case involving this, the Hill case, where we had auditors appointed. Let me get rid of, I don't know why people are calling me. I do have, there's a way to tell the court, tell the phone that I'm do not disturb, but I have not figured out how to hit that button. So I apologize for that. Okay. So, if you read 172, it deals with situations where you're asking a party, asking an auditor to go in and essentially calculate something in an account, or vouchers. It mentions those where you add them up, and that's a way to save everybody time and money because it permits that. What Your Honor is doing, or what Mr. Seymour is trying to get you to do in this order, is to determine the propriety. That is this legal under these and allowed under the court, the documents, the applicable contracts, minutes, or resolutions of the company, of the board of directors. That means that the auditor is doing something the auditors do not do, which is they're making a decision as to the propriety of those. And they can't do that. That's not what an auditor knows how to do. It's asking for a legal opinion. I know, for example, if we had a person take the stand as an expert in your case, in our case, and they purported to tell you what a contract said was required, Your Honor, no doubt, because I have tried cases in your court, would tell me that that is something that you determine, and not the this expert, this auditor. If I said, does it comply with the minutes or the board of directors, you'd say, you can't do that. That's not what the board, that's not what an auditor does. And so here we have you ordering something which the auditor can't possibly do. The last thing is it leaves off a large portion of the case, which is the decree of divorce, and you're going to hear this on Monday, creates relationships just like any other, like a will or anything else, or a trust instrument or any other situation. It created essentially agency relationships and created relationships that are fiduciary relationships. And it's not asking whether or not those have been violated or whether or not that is an overlay. Remember, this is 100% of the stock of this company is now being governed by the DOD. And that created the fiduciary relationship where one party has to act with fiduciary relationship because they are agents in terms of the distributions and the amount of information that is supposed to be equally supplied to my client, which has not been. And so as a result, you're going to end up with a situation where the auditor is going to come in with something, and I know what you ordered, and you know that I have enormous respect for this court as well as all courts, but I just think this exceeds 172, does not deal with the DOD in a way that makes sense, and sort of ignores the claim.
Mr. Lynn, let me just say this, and I share with you a certain frustration here, which is I think the Court of Appeals, I understand what their thought process was in terms of kind of dividing this case. I kind of thought the case should all be in family court. What I don't really understand, and I never really understood, and you at least seem to be, of all the attorneys in the case, the most closest to me in terms of, hey, why isn't this happening, is I don't know how especially with the current order out of the Court of Appeals or opinion out of the Court of Appeals, can say, hey, I'm going to appoint an auditor to make sure that they're complying with the divorce decree, because that's not an order out of my court. What really should happen in this case, really, instead of having an auditor or doing any of these things, is you guys should go to Judge Brown and say, hey, look, we're trying to sell this. They won't sell it. You need to appoint a receiver and get this thing sold. I mean, that's what needs to happen. There's already an order in place, and that why we're fighting over all of everything in this case, that doesn't really make a lot of sense to me, given what the orders are in that case, at least as to all of this. And
Your Honor is quite correct that I've heard you speak on this case, and I think that your thoughts and my thoughts are closer than perhaps some of the maybe previous lawyers that were in this case or the lawyers that are in this case now. But the difference between what Your Honor is thinking and the gestalt, the difference between what I'm thinking and I think what Your Honor is thinking, I ask Your Honor just to consider this, is that a court, that family court, can issue an order, and that becomes cement. That becomes an order that creates a relationship amongst the parties. Once that relationship is created, the issue is then in your court, was it breached? Not whether the duty that flowed from that was breached, not whether the order was, we're not talking about how to interpret the order.
I wouldn't necessarily disagree with you, but for the wording of the Court of Appeals order that said that anything dealing with the divorce decree and a breach of the family code, or I don't know exactly, but I think it really dealt with the breach of the divorce decree, needed to be handled by Judge Brown, and everything else had to be handled by me.
Except that left open the possibility that it did not deal with the possibility that you have before you, which understandably is unique, but it is the one that I asked you to consider. And I think it's fundamentally on your shoulders to make a determination that once the duty is created, that is, the fiduciary duty is created, whether or not that was breached, not whether the order was breached, but whether the duty, the fiduciary duty that was created as a result of the agency relationship created by the order, whether that fiduciary relationship is breached. I mean, we have all sorts of examples of this in law where a document or an order of a court will create a relationship, and then that relationship creates the duty of a fiduciary, and then the issue is whether that's breached.
So, Your Honor, unless I'm going to get CLE credit for this lecture, this was not on the agenda today. The only thing on the agenda today was to find out whether Seymour Roberts properly followed your instructions and prepared that order.
Okay, to that end, and Larry's right, he should never get CLE credit from anything because Larry and I don't agree on much. And we've been adversaries and on the same side for most of my professional life. But the one thing that I saw that was missing is you at the end on the issue of payment, the 50-50 payment. You said that you would reconsider or think about whether to award those costs to the company in total. And also, you also said something about look at the results of the audit and determine who should pay. I'm not sure which of those trumps the other, but you mentioned both of those. Those are not reflected in this order.
Well, Judge, can I respond to that? Mr. Lynn sent me back an email saying that my order reflected what you said. If he had said that to me in his email, what he's saying now, my order might have said something different. But for him to argue this point now, after he sent me an email saying, Seymour, it reflects what the judge said, I think he's a stop from raising anything else now.
Well, that's what I think. You asked me if I had objections or concerns, and that was one. And whether or not, and it's true, Seymour got most of the rest of it right, but he missed on that one.
Okay. I understand what you're saying. I can deal with that at some future point. If it comes to that, Mr. Roberts did point out a slight issue with the order involving the party shall be entitled to file exceptions or objections to the report no later than, and it's before the report is due. So we do need to change that date. I don't know why you should be able to give, I just don't understand why you guys get to object to the auditor's order. But if you guys both want to, I guess you can. So we'll move that to February 2nd. And when is your mediation on this?
The 17th and the 18th, Your Honor.
Okay. All right.
Mr. Lynn has mentioned more than one time that he plans on filing a motion to abate this case. Gail Fisher's the plaintiff in this case. If she doesn't want this case, or if she doesn't like this case, she can simply dismiss it, and we'll deal with it in the family court. They don't need an abatement. They just need a notice of dismissal.
I don't remember ever using the word abatement. I don't think it's anything in any of the, I don't think any of the transcripts that I've read of our hearings reflect me saying that. So I just disagree with that.
Okay.
I do think there are some things, I think there are some things coming up. I think that the issue of settlement, I think the issue of a pretrial scheduling order, I think the issue of some new pleadings and some new discovery on this case are going to be before Your Honor here pretty soon. And that's what we're going to be looking at. I feel like that, first of all, I have enormous respect again for this court. I've tried cases in your court most of my professional life. Probably when you see me coming, you hide because you think that I'm going to be making things difficult for you.
That's not true at all.
But
it's true on my part.
I might add, Larry makes things much more difficult than they need to be.
Thank you. Please spread that around.
I'll be glad to get a transcript and let you frame it. But I do, as Your Honor pointed out, has just done laughing. I think I laugh at myself as much as Larry laughs at himself. So we can get along on this. But I'm moving into a case. I have done a pretty decent job of reading all of the different hearings. I'm about a third of the way through the divorce trial. And I am also making, I think, a good progress in terms of getting a handle on almost all of the orders that have been issued. I read about 2 hours a day to try to get through this stuff. I might add, there is a lot of water that's gone under the bridge. So I understand that. But as any new lawyer would, as Your Honor would, if you were practicing in my stead, I see things that maybe others didn't see with fresh eyes that come in. That's not indicating anybody did anything wrong. It's just saying that there's no way two lawyers look at the same set of facts and don't see new things. I ask Your Honor's patience in the sense not of me learning it or understanding it, but in terms of the fact that I be given some leeway to shape the case in the way that we would like to try it. You can already see that I've dismissed out the accountants. There might be some other parties that might get out of this case if I continue to work through this thing.
But here's the problem.
But I cannot have both my arms and legs tied behind me to prepare a case that is
Mr. Lynn, I understand completely what you're saying. You also have to understand that you jumped into the ninth inning of the game. And, if this is a baseball game, you jumped into the ninth inning, and you can't just say, well, Judge, can we just forget the first 8 innings that already took place and start the score over at 0 again? It's
not trying to do that.
And so, but I do think that you made some extremely insightful comments in the case about what needs to happen. And to me, it's Mr. Friedman's going to totally disagree with this, is that 90% of the issues in this case could be resolved if you just went to the family court and say, hey, look, we need to get the sale done. I mean, that's, if that isn't going to happen, then somebody needs to buy the other person out. I mean, that is and why we've been fighting over all of this. And I understand your argument, Mr. Friedman, that nobody really wants that, but that's what needs to happen. I mean, that's either one side buys the other side out, or it needs to be sold. I mean,
so we'll address that at mediation next week. But I think you hit the nail on the head. This is the ninth inning. This is the bottom of the ninth, and we've been in this case for so long, and so much water has passed under the bridge. And respectfully, Mr. Lynn would like you to start this ball game right from the beginning. He'd like the first pitch, and that's unfair to our clients who have suffered through this case to this point.
I don't disagree with you there.
This is the World Series, and we're not even in the last game.
All right, enough baseball analogy, guys. Great to see you. I saw you.
Judge, do you want me to revise the order with?
No, I already just changed it, signed it, everything.
Okay, thank you.
Good.
Thank you,
guys.
And
we will, I'm sure, see you again next week.
And Judge, I don't always bring you pains in the neck or wherever, or even lower than that.
Yeah, I always enjoy working with you, Mr. Lynn, and you're a great lawyer, and so is Mr. Friedman and all the other lawyers in this case. So we will see. You guys have a great weekend. You be safe, okay?
Thank you, Judge.
Thank you, guys. Okay, I think our next case is Westco Distribution versus O3 Construction International. Anyone here in that case?
Yes, Your Honor. Misty Beanland for Westco Distribution, Inc.
Your Honor, I'm Maureen Farrell, and I'm appearing for O3. And I believe that my client, Brad Stutzman, is here as well.
You guys,
yes, I'm here.
Hello, Mr. Stutzman. Do you need an order? Do you need a record on this? We don't usually do those on summary judgments, but if you need one, we'd be glad to get one for you.
No, Your Honor.
Yeah, I don't think we do.
And this is on YouTube, so if there is any discrepancy about something, you can always go look back on the YouTube. So, all right, let's get started on the summary judgment.
Yes, Your Honor. Misty Beanland for Westco Distribution, Inc. This lawsuit was filed on August 9th, 2021. against O3 Construction International LLC. My client, Westco Distribution, is an electrical supplier. Attached to our petition was an affidavit of sworn account, as well as a copy of a credit application that was signed by O3 Construction, copies of the unpaid invoices. And on August 31st, the defendant filed an answer. It did not include a sworn verified denial as required by Rule 185. On September 21, Westco Distribution served its initial disclosures to the defendant, and defendants then served their initial disclosures on September 27th. On October 25th, Westco amended their disclosures and served those on defendants. So there has been some discovery between the parties. On November 11th, the plaintiff filed a motion for summary judgment on the sworn account, and plaintiff and defense counsel on December 31st entered into a Rule 11 agreement that would allow the defendant until Monday, January 3rd, 2022 to file their response to our motion for summary judgment as it was set for hearing today. And on January 3rd, the defendant filed a response. We filed a reply to that response on Wednesday. I don't know if that's in the court system, but plaintiff filed a reply objecting to the defendant's summary judgment evidence. The reason for that is the only attachment to defendant's response was an Exhibit 1, which purported to be an email from a representative of the defendant to counsel for defendant. There was no affidavit proving up that email. And so we object to the Exhibit 1 to defendant's response, that it has no foundation and is inadmissible hearsay. I just received notice approximately 10 minutes ago that the defendant has filed an unsworn declaration of Brad Stutzman, basically stating that the substance of the email, again, this is a motion for summary judgment. Any evidence that the defendant was required to place before the court as evidence for their response needed to be filed on January 3rd, which was the deadline that was extended for the defendants by Rule 11 between the parties. In our motion for summary judgment, as I stated, my client is an electrical supplier. They sold materials on credit to the defendant and are owed the sum of $47,593.15. We attached an affidavit of a representative of the plaintiff proving up that those materials were sold on credit and had not been paid. Attached to the affidavit on page, that would be 10 of the motion for summary judgment, page 10, is the credit application that was entered into. It's called Application for Business Credit by O3 Construction. The terms of the payment provided in the credit application shall be net 30 days with past due balances subject to a service charge at the rate of 1.5% per month, which would be 18% per year. And they also agreed that they would be liable for collection of any amounts, including attorney's fees. Again, we attached copies of the unpaid invoices and statement, and the demand that was sent to O3 Construction on June 21, 2021. And again, stating that those amounts have not been paid. We also attached an interest calculation, that's page 27 of the motion for summary judgment. calculating the prejudgment interest on $47,593.15 from June 16. The unpaid invoices were incurred in April. So we added additional time and began the interest on June 16th. And through November 3rd at 18%, the prejudgment interest that we are seeking is $2,546.23. I also attached an affidavit of attorney's fees, setting forth the work that had been done on this case. Again, the credit application provides that the defendant is liable if we have to pursue collection of the unpaid materials. And we are seeking attorney's fees of, we are seeking attorney's fees in the amount of $3,700. And we've also included an uploaded order of judgment, a proposed judgment for the court to consider. In closing, again, pursuant to our reply, we object to the response. We object to this unsworn affidavit that was filed this morning as being untimely, and are requesting that the judge enter judgment in favor of the plaintiff for the principal sum of $47,593.15, prejudgment interest $2,546.23.
I got it.
Okay.
Ms. Farrell, what's your response?
So with respect to the evidentiary issues, it is correct that Exhibit 1 to our response was an email from Mr. Stutzman, who's here, to myself regarding payments that O3 had made to Westco that weren't reflected in there.
Let me ask the first question. The initial answer was, or original answer was filed without a sworn verification, so it wasn't a sworn denial. Was there ever a sworn denial filed?
No, I don't think so.
Okay. Go ahead.
So Mr. Stutzman's email was exhibited to our response for the motion for summary judgment. Obviously, Your Honor, we'd ask for the court to make to admit both the Exhibit 1 and the supplementary declaration that was filed this morning, under the principle that the responding party should have the opportunity to correct any defects in late filed evidence, or to correct evidentiary defects. So the email is not late filed. The unsworn declaration is, but that was an attempt to correct the evidentiary defects that were pointed out.
Rule 166A, I believe, is what you're referring to. I'm not sure if
that is correct. And also case law with respect to under tri-seal structures, that the party should have the opportunity to correct.
Deal with the issue of whether or not the affidavit is defective, not whether or not you have. Are there any cases out there that say that if you file evidence and there's not an affidavit filed, that you can file a late filed affidavit?
The objection to the admissibility of the evidence that was filed was made on the basis that it was not, there was no foundation for it, which is a defect. Ms. Beanland was pointing out a defect in the evidence filed with the response to the MSJ. So I think that's squarely under the idea of that the party should have the opportunity to correct that evidentiary defect.
Ms. Beanland, just respond to that argument.
No, Your Honor. If you look at our reply, our objection was they attached an exhibit to their response that did not contain an affidavit. It had no foundation. It's therefore hearsay, not that there was a defect. And on the last minute, 10 or 20 minutes ago, to file an unsworn declaration, again, gives my client no opportunity to review or respond to that. The whole purpose of the motion for summary judgment is to allow the defendant at least 21 days to gather a response in their evidence and file that within 7 days of the hearing, which would allow my client an opportunity to gather any other evidence or perhaps, extend the motion to amend its motion if needed based upon a response. We haven't had that opportunity. Again, they have not verified their denial. So under 185, actually, they're precluded now from asserting a verified denial to the pleading. Again, this case has been on file since August. They complain that discovery has not been done. They've had an ample opportunity to submit any discovery requests. None have been provided. None have been served on my client. And the motion for summary judgment, my burden has been met, and they have failed to meet their burden in response.
Court is going to go ahead and grant summary judgment on this based on the reasons given in the briefing and the pleadings. Anything is, and that's a complete summary judgment, as I understand it, the entire case.
Your Honor.
Yes, Your Honor, and we have uploaded a proposed judgment in the
Signed it.
file.
Your Honor, is that on liability or on the total amount of damages as well, which really is the dispute here? I mean, so I think that the MSJ did come pretty quickly, right? So I think in the response, it says that we had 4 months to serve discovery, which really isn't true because disclosures were only completed at the end of September. 03, I think, accepts that there is some liability to Westco, but disputes the amount. And there hasn't been any discovery. My client was in the process of doing an internal investigation to figure out what amounts had been paid. And so I think that we would request that the court allow an additional evidentiary hearing on the amount of the damages alone.
Ms. Beanland, do you agree to that?
No, Your Honor. I have produced an affidavit from my client swearing that the amount is true and correct. They have failed to come forth with any evidence that that amount is not correct.
Yeah, unfortunately, the law is pretty clear on this. There's no sworn denial. Summary judgment evidence was late and not properly authenticated. For those reasons, unfortunately, I need to go ahead and grant the summary judgment. It's not something I really enjoy doing, but I think it's something I'm required to do according to the law. So, all right, guys, thank you so much. You guys be safe, okay?
Thank you, Your Honor.
All right, our next hearing, and I have signed the order. Karis MPI versus United Healthcare. Is everyone here on that case?
Yes, Your Honor. Nicole Munoz-Hushka for defendants.
And
Good morning,
Tony,
Your Honor. I'm sorry.
go ahead, sorry.
I was just going to say Megan Self on behalf of Karis MPI.
I mostly am just having a hearing. There's, I think, $100,000 bond on this that there was a request to release, and I just want to kind of make sure that everybody's on the same page that should be released. I anticipate this will be very short, but let's go ahead and go on the record. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 2117101, Karis MPI versus United Healthcare Inc. Counsel, make your appearances.
Thank you, Your Honor. Danny Toby and Megan Self from DLA Piper on behalf of Karis and Ms. Dyer will be doing the presentation today.
Okay.
And Nicole Munoz-Hushka on behalf of all defendants.
So my understanding, did I get was there somebody else?
No, it'll just be me, Your Honor, for defendants.
Okay. My understanding was that we were going to discuss the release of the funds in the court registry of $100,000. I just wanted to make sure that everyone agreed to that. There was no issues with releasing that.
Defendants are unopposed.
Okay. All right, I'll go ahead and sign that order. I have a note from the clerks that there's a motion to permanently seal documents. Is that set for today? I didn't know that.
Yes, Your Honor, that is also an unopposed motion.
Did you guys And is that agreed to?
It is agreed to from defendants.
I don't see an order on that. Is there an order on that?
An order has been submitted, but I'm happy to recirculate that if it would be helpful.
Let me see if I can find it. Maybe I'm just missing it. When was that order filed? Do you know?
On December 15th.
Okay, maybe I just am missing it. Let's see. I may have it. I maybe just missed it. Let's see. December 15th. Wow, there's a lot filed in here. Okay. Should this case be closed, or what? Is this case still active? I'm a little unclear what's going on here.
It's been removed to federal court.
Ah, okay. Well, can I even sign a permanent sealing order then?
Yes, Your Honor, under the Rule 76A specifically says that the court has continuing jurisdiction over its sealing orders. So because of that, we think this court still has jurisdiction over this particular order.
Is anyone claiming that I don't have jurisdiction at this point since the case has been removed?
Defendants believe that the court still has jurisdiction with respect to the sealing issue.
There's another order I just printed out. Let me give you this one. Okay. I'll go ahead and sign that. Is there going to be an effort to remand this case, or is this going to stay in federal court? Do you anticipate?
Plaintiffs are considering all of its options right now. We have not reached a conclusion on that.
Okay. I'll let I really think the case is listed as inactive. I really think it should be closed. So let me find out why the clerks haven't closed it, but that doesn't matter to you guys. Okay, anything else we need to chat about today?
That's all plaintiffs have, Your Honor. Thank you.
Defendants have nothing, Your Honor.
Well, good to see you, Ms. Munoz, Mr. Toby. It's been a while. I hope you guys are both doing well, and you guys be safe out there, okay?
You too, Your Honor.
Happy New Year.
Thank you. Happy New Year to you as well.
We excused?
You are excused.
Thank you, Your Honor. Have a good day.
And I've signed both orders.
Thank you.
you.
Okay. Is anyone here on the Ibrahim case? It's a little bit early, so we may not have everyone here yet.
Yes, Your Honor.
Yes, Your Honor.
Both sides are here. Are we expect anyone else to show?
No, Your Honor, I don't believe so.
Okay. Tony, let's go on the record on DC 218296 Ibrahim versus Donna. Counsel, make your appearances.
John Rosé for for the plaintiff, Your Honor.
Kimberly Shepard for the defendant, Daniel Dominguez.
All right, let's proceed.
We filed an agreed motion to transfer venue on August 30th, and our order came back unsigned. So we set this hearing.
Okay. Let me pull that up and take a look at it. This is a case, I think the accident happened in Tarrant County. Is that right?
Correct, Your Honor.
Yes, Your Honor. I believe it was just right on the line, so it was just a clerical error.
I once had a case when I was in private practice where it was on the border of the Dallas and Collin County, border of Dallas and Collin County, and the accident started in Dallas County but ended like as the car spun out in Collin, and I wanted back then to desperately keep it in Dallas County, and anyway, the Judge Greenberg at the time, who was this was many years ago, was the judge, and he denied multiple attempts to transfer it. And so I appreciated that. I thought that was anyway. So I'll go ahead and transfer this since you guys all agree. It does say it's hereby transferred to the blank in Dallas County. What am I supposed to put in the blank?
Oh, let me pull up the order.
You usually just say it's transferred to Dallas County.
transferring to Tarrant County, whatever.
Because I don't transfer to a particular court in Dallas unless there's I guess, an existing case. So it should just be, I think, to Dallas, to Tarrant County, right?
Okay, I understand. We can resubmit.
I'll just interline it. Don't worry about it.
Okay.
So, all right. Anything else, guys?
No, Your Honor.
Not at this time. Thank you, Your Honor.
You guys be safe. We will sign the order right now and we'll get it transferred.